This video is going to talk about slip and fall accidents or premises liability accidents. My name is Bill Karns. I'm one of the co-founders of Karns And Karns, a personal injury law firm. I've been handling premises liability cases for about 20 years now. And look, these cases are really interesting and they're a lot of fun. A lot of people don't understand what makes a defendant liable in a slip and fall case. So let's take a couple of examples. Let's say there's some water on the floor or grape on the floor at that supermarket. You step in it, you slip, you fall, you get hurt. Was the supermarket at fault? Well, let's talk about it. There can be water on the floor or grape on the floor and the supermarket may not be at fault. But the key is if they knew about it or should have known about it and they didn't do anything to clean it up, then that supermarket's on the hook. And that's the key thing in premises liability cases. If there is a dangerous condition of the property, it could be anything. It could be that grape, that water. It could be a dangerous stairway. It could be something on a construction site accident. It could be anything. A lip in the floor, a tree root that uproots a sidewalk, anything like that can be a dangerous condition to people just walking around minding their own business. Number one, there was a dangerous condition. And number two, did the defendant know about it or should they have known about it? If you capture that number two threshold, you're good to go on your premises liability case. That's what lawyers do on these premises liability cases. Their whole goal on liability is to prove that the defendant knew or should have known of a dangerous condition. And the way to do that is get a ton of documents, we get witnesses, we take depositions, and we try to show that the defendant did know about some type of dangerous condition that contributed to your fall. And if they didn't know about it, we argue that they should have known about it. So let's go back to that supermarket incident. We have got the grape or the water on the floor and the defendant is saying, look, we didn't know about it. We didn't know anything about it. Well, then the question is, did you inspect your premises? Because you have an obligation to inspect your premises. And if you don't inspect your premises, then you're going to be responsible for that water, that grape. In other words, it's going to be presumed that they had knowledge of it if they failed to inspect that premises. And that's the real key thing on these cases, is proving that the defendant should have known about a dangerous condition, because they often deny that they knew about a dangerous condition. Sometimes the defendant causes a dangerous condition. Sometimes people are moving their grapes or whatever it may be around and there's water coming off the cart. They're not doing anything to clean it up. Well, then they knew about it because they caused it. They don't even have to worry about whether they should have known about it. So there's a lot of these little factors in premises liability cases, but the ultimate goal is to prove that there's a dangerous condition and the defendant knew about it or should have known about it. Once you have that, you got a solid case of liability in a premises liability case, a slip and fall case. Now, the injuries from slip and fall can be really anything, right? I mean, you may injure your head, neck, your extremities. You might have tears when you twist a knee going down. You may have fractures when you bump your arm going down. You may hit your head and have a traumatic brain injury. All sorts of injuries can result in premises liability cases. Serious injuries. There's even been premises liability injuries that have resulted in death. So the types of injuries that can result from a slip and fall, a premises liability case, exceedingly vast, really vast. So if you have a premises liability case, you got to make sure you have lawyers that understand how to make the defendant liable, make them responsible for that loss, proving that dangerous condition and proving that they knew about it or should have known about it. That's the key. At Karns and Karns, we've handled over 1,000 premises liability cases. We know exactly what needs to happen to make sure that every little box is checked to prove that defendant knew or should have known about that dangerous condition so you can win your case. If you got further questions about premises liability, slip and fall accidents, contact Karns and Karns. We're here for you.